The Federal and City Union Bank jointly present the Tanjavur Marathon 2025 on Sunday, February 23. This event is powered by Sri Kamachi Medical Center and Anandam Silks and organized by Tanjavur District Athletics Association.
Hello and a warm welcome to Federal's special program Capital Beat. Supreme Court today has fixed February 19th now to hear the pleas against the appointment of the Chief Election Commissioner and election commissioners under the 2023 law, saying if anything happens in the interregnum, the consequences are bound to follow. Now, this was a bench of Justices Srikanth and N. Kotishwar Singh, and they were told by Advocate Prashant Bhushan, appearing for Association for Democratic Reforms, that earlier the pleas were scheduled to be heard on Wednesday, but now they have been listed for hearing on February 19th. Now, Chief Election Commissioner was supposed to retire on 18th, and now if this hearing is scheduled for 19th, how does it unfold? And apart from this, Supreme Court has also given a direction yesterday to the Election Commission that the EVM data should not be deleted, neither should a fresh data be reloaded. And apart from that, they have also asked the Election Commission to reduce the cost of the EVM verification. So, what does all this mean? Joining me now is Professor Jagdeep Chokhar, founding member of the Association for Democratic Reform. So thank you so much for joining on the Federal. And I'll begin with this hearing, which has been postponed to 19th of February regarding the appointments of the chief election commissioners and election commissioners. Now, what does it mean? Because Rajiv Kumar is supposed to retire on 18th, and now this hearing is scheduled to be happening on 19th. So, what is the guarantee that the government will not appoint the new chief election commissioner during this particular period?
Well, there is no guarantee. As a matter of fact, last time when the original petition about the appointment of election commissioners and the chief election commissioner was actually being heard, while the petition was being heard in the Supreme Court, an election commissioner was appointed within 24 hours. And the Supreme Court called for that file, and the Supreme Court recorded in the judgment that it was at lightning speed that this appointment was done. So there is absolutely no guarantee that at a chief election commissioner or an election commissioner, two appointments might be made on the 18th of February. One doesn't know that, and therefore there is no guarantee at all.
No, but sir, couldn't the Supreme Court have passed an interim order where they could have put a stay on the appointment, at least till the time this hearing is pending? Couldn't have they done that? What we are told is that apparently one of the judges was not well, and that is why they had to postpone the hearing to 19th. But couldn't the judge could have passed an interim order, putting a stay on the appointment? They could have done that.
Well, they could have done whatever they felt was judicially appropriate, and this certainly would have been appropriate, but it's not been done. That's all I can say. We had even earlier, when this law was passed, we had applied for a stay, but that application to stay was not granted even then.
Right. No, but if the stay wasn't granted, then if there is no order now, interim order, so what does one conclude or infer? That has the court given a long rope again to the government? How will one read this situation now? Given the fact that Rajiv Kumar is supposed to retire on 18th and the hearing is now on 19th, what sense does it actually make? Has the court now given a long rope to the government?
You see, the court maintains that they don't work for the government or against the government. So the court says that a law passed by parliament legitimately cannot be stayed without an appropriate hearing. So the court, in its mind, is trying to uphold the sanctity of parliament. But
Okay.
it appears to me also that the court is giving a long rope to the government. But that is not the court's perspective. So what does one do? Each one is sitting on his or her pedestal
True.
and not not very keen to look at the ground where reality is happening. Particularly when the example of the appointment of an election commissioner while hearings were going on in the court is there. It is not 200 years ago or 50 years ago, it was 4 years ago or 2 years ago. That memory is very fresh in my mind. I am sure
Right.
it is fresh in the minds of the judges who are dealing with this.
Absolutely, but does it look like a risky situation? Risky situation in the sense that activists like you who've been fighting for the electoral democracy, does it come as a because we'd all expected that there could be some kind of a stay order or some kind of an interim order which could have given at least some hope. But right now, that hope eludes everyone. What is the
No, no,
situation?
no. It has not come as a surprise.
Okay,
What is surprising is that uh, a particular judge, and I'm not casting any aspersions at all, but a particular judge is not feeling well, he is not able to attend the court, and therefore, in the normal course, the hearing has been put off.
no,
This
but
is a
is
surprise.
that,
It is
but
it is a coincidence.
right. No, it indeed is a coincidence, and I'm not raising any questions or casting aspersions on the judge, because if the judge is unwell, then they might be well within their rights to postpone the hearing. But the point is that if you look at the urgency factor, that how urgently the issue is being treated by the court, that is also something which is of prime importance. And if you look at the what the bench has said, and I'm just going to quote, anything happens in the interregnum, then the consequences are bound to follow. So if the bench is saying that, does this line look like a mild, uh, an ultimatum to the government that, look, you cannot appoint anyone before 19th of February?
You know, the the courts are very careful in how they say what they want to say. In my simplistic view, if the court did not want any appointment to happen, they should have said so. And they could have said so. But they decided not to say it. They decided to put it mildly or give a hint. Now, whether the government takes a hint or not, it's for the government to decide. And what exactly is the hint, I don't know. If they meant to say that please do not appoint anyone before we hear this issue, they should have said so. So the court
Absolutely.
is also being a little circumspect, and that
Okay.
circumspection perhaps gives leeway to the government to do what it wants.
Right.
But
So
no, you cannot say. I mean, that sentence can be correctly and legitimately interpreted to mean that if anything untoward or undesirable is done, there will be undesirable consequences. It can legitimately be interpreted to mean that. But it can also be legitimately interpreted to mean, but please don't do anything wrong. It will not be nice. So these are different interpretations of the same thing.
but does one also read this particular postponement of the hearing as a soft approach which the court has taken towards the government? Would one read it that way?
Well, one could do it that way, but it is very difficult to interpret the court's intentions. The courts are, they also work under very, very complex circumstances. They have to balance a whole lot of things. I mean, it is simple for people like us to say they should follow the constitution and just go according to that. But very often that becomes difficult, and the courts are also cognizant of what is happening in the country. But I believe they should stand by the constitution regardless of the consequences. It is an
Right.
extreme kind of statement, but I believe that is the court's role in the system of separation of powers and all that.
But in your view,
So,
Professor Choker, how urgent is this issue? when it comes to safeguarding and protecting the electoral democracy, and when there's been such a lot of hue and cry about the bias of the election commission, and also the manner in which you don't have a third voice at all in the appointment of the election commissioner. So couldn't the courts have treated this matter urgently? Because what if the government appoints a CEC of their own choice and you don't have a Chief Justice of India on the panel? There's just one leader of the opposition and then the Prime Minister and his own cabinet member. So obviously, whoever becomes a CEC will be the government's man.
Well, you are absolutely right. That is a distinct possibility, number one. Number two, I believe completely that this is about the most urgent matter in the democratic life of this country today. And it has been so for many years. Otherwise, we would not have filed that original petition and we would not
Absolutely.
have challenged this law made by the parliament. Number two. Number three, now, given the sentence that you read out, if a CEC is appointed by the government, we will again go to court challenging that appointment. And we will ask the court or request the court, please let us know what are the adverse consequences that might follow. So the
Yes.
question is, we are not going to give up on this issue. We will take it to its logical conclusion whenever that conclusion may be available. But certainly, in our opinion, it is the most urgent issue, and the court should have taken it on immediately without any delay. But unfortunately, our view does not matter. What matters is what the court decides.
Okay, I'll go back to now the hearing which happened yesterday, and Supreme Court has given certain directions to the Election Commission regarding that the data should not be deleted, no fresh data should be reloaded, and there should be no tampering with the SLUs. Then they've spoken about bringing down the cost of the EVM verification, and I'll go one by one. Now, let's begin with the data deletion the Supreme Court has said. Now, how do you read this direction given to the election commission by the Supreme Court? That Supreme Court has taken cognizance of the fact that yes, the data has been tampered, the data has been deleted. Is it an acknowledgement of that? If the SC has given a direction to the EC on this regard?
You see, this is very unfortunate. This direction was not required to have been given. Election Commission, in its own
True.
wisdom, should never have done that. The Election Commission misunderstood or misrepresented or misinterpreted the direction of the court given in its judgment of April 24, 2024, that it should arrange for checking and verification of the burnt memory and the microcontroller of the EVM and VVPAT. Now, checking and verification of the burnt memory and the microcontroller of EVM and VVPAT was interpreted by the Election Commission as a mock poll. This is where either the mistake or the mischief lies. It does not need rocket science to say that if the Supreme Court wanted a mock poll to be done, it would have said do a mock poll.
No, you spoke about two words, Professor Choker. You said, was it a mischief or a mistake? In your view, I'm talking about your opinion. How do you see this on the part of the Election Commission? Was it a mistake or a mischief? How would you see that?
I will not say anything on this issue. The technical standard operating procedure goes into great length to describe what is possible, what is not possible, and then at the end it says it will be a mock poll. In other words, it doesn't say a mock poll, but it says what it describes as a mock poll. So by a mock poll is a mock poll is a mock poll for anybody who understands it. And people who contest elections and who study elections, who observe elections know that. So the Election Commission thought that this mock poll described in flowery words will escape attention or escape give notice and they will get away with it. This was, I think, a little naive of them. This came to light soon after the technical SOP was issued. We did not go to court immediately because we thought, let us see how it plays out. And when it started playing out, this direction was issued in April 24, I think, or 26, 2024. Even after the Lok Sabha election, I think, if nothing else, at least 11 candidates had applied for this checking and verification. And then in Haryana and Maharashtra, it has been applied by hundreds of people. Till today, no checking and verification has been done. This is a fact. Now, therefore, one, Supreme Court directions have not been followed. Two, Supreme Court directions have not been followed correctly. Therefore, the onus for this certainly lies on the Election Commission. And it was in that context, you see, when one losing candidate who filed a petition, he had applied for checking and verification, but nothing had been done. He challenged the technical SOP. The other candidate actually went for a physical checking and verification. And according to reports that I have seen, when the checking and verification process started, the engineers from BEL and ECIL had come. They took out EVMs, and I believe on the first EVM said there was a problem with that EVM. They took out a second EVM, and they deleted all the data in the EVM. And they said, now you put fake candidates, and then we will do a mock poll. That is when the candidate said, this is not what I have paid for. And it was stopped there. So the fact that votes polled in the EVM were deleted is beyond doubt. And when this came to the attention of the court actually they sounded quite surprised. I think at one stage, one of the judges said, why did you delete the votes? And they said, please do not delete the votes. So the fact that the Election Commission has deleted the votes cast in the EVM before conducting the checking and verification is now beyond question. And it is, on the face of it, not correct. It is not something that is expected or should have been done. I think it is a very serious matter. I hope the court had taken a more serious view of it and chastised the Election Commission more rather than just saying, don't delete the votes. Why did you delete the votes?
Right. But do you think that this matter has got delayed because even during Haryana elections, similar petitions came to the Supreme Court and they were not entertained regarding the EVM data deletion and also about the cost of the verification? All this matter came up, but it's now that the Supreme Court has given directions to the Election Commission. So is it a case of better late than never? Now it's realized that, okay, we've got delayed and now Supreme Court has given directions to the EC.
This is a long story and a complicated story. The petitions were filed, they were referred to different benches, and those benches then referred them to other benches. So there has been a bit of a runaround in the Supreme Court, caused not by the litigants, but by the court itself. And during the hearing, which has not come on record, the judges did say that, yes, some mistakes may have been made in the registry in marking of the cases, and we are trying to improve that. So there has been a fair bit of a round, but I am glad finally, as you said, better late than never, that the court has taken serious cognizance of this issue, and let us see where it takes us.
Now I'll come on to the cost of the EVM verification. Now there has been an exorbitant cost which has been put on the verification process of the EVMs. That's about 47 lakh or something or EVM, and that's something which is beyond
47,000 plus
47,000, yes.
For each EVM.
Yes. So
when you apply for 10 EVMs, it becomes 4.7 lakh.
Yeah. So if that is the amount, sir, so now if the Supreme Court has asked the Election Commission to bring down the cost, so what in a way is Supreme Court expecting from the Election Commission, that now the poll body is going to come up with certain guidelines that look, this is the cost we are revising, or the cost will be told by the court? What can we expect in terms of the cost of the EVM verification?
You see, the cost given by the Election Commission in its standing orders was a random figure. It shows, 47,000 XYZ to make it look very accurate and as if it had been determined with great accuracy. But it seemed to be a random figure. But what is going to happen now is nothing is going to happen. The Election Commission is going to give a response to the miscellaneous application filed by the ADR and the petition filed by this second candidate. Election Commission will give a response, which I suspect will try to show that what the Election Commission is doing is perfectly all right and there is nothing wrong. And perhaps they will give a lower figure. Perhaps they will try and justify this figure. I do not know. But the Supreme Court has definitely said the cost is excessive. In my opinion, it is excessive. And even if you read the administrative SOP, I wrote an article on the administrative SOP in The Wire. The administrative SOP itself clarifies beyond doubt to any discerning reader that it is not meant to be done. And that is exactly what has happened, and nothing has happened in over a year after the order was passed. So the Election Commission does not seem to be interested, and I say this rather carefully, they do not seem to be interested in checking and verification of the machines and the VVPAT and also of the SLU the way the Supreme Court has desired. Because there is a tendency in the Election Commission to say everything is fine and you accept it because we are saying so. Now, that is not an appropriate approach. Election Commission, the Chief Election Commissioner has repeatedly said, we are guided by three principles: disclosure, disclosure, disclosure. He has made this statement more than once. I have heard it being said by him
Yes.
on videos. But in their actions, they have done very little to disclose anything. So this difference between what is said and what is done is what is causing all the problems. If they were to be open about what they do, there are a lot of people. I mean, I don't know what the political parties are up to. They are into winning and losing. There are several institutions in the country like us who are not interested in who wins, who loses. We are only interested in that the electoral process should be robust, and it can be robust not only by saying it is robust, by being transparent. We have been trying to improve the electoral process for 25 years. But Election Commission says everything is fine, believe our word. And at times, the Supreme Court is inclined to believe the Election Commission words. That is where the difference of opinion is. The Supreme Court, as an independent entity, the supreme entity, should also ask the Election Commission to be a little more open and explain things.
Absolutely.
As simple a thing as in the Lok Sabha election, in 538 constituencies, out 543, the votes counted and the votes polled in the EVMs were different. Now, till today, the Election Commission has not explained this satisfactorily. They have given vague reasons. But in the Delhi election, except for 5, they are identical in all constituencies. So it proves that it can be done. It should have been done even in the Lok Sabha. But Election Commission doesn't own up as to how come it did not happen in the Lok Sabha and how come it happened in Delhi. They should come out. They are a institution which is answerable to the people through the constitution. So they should tell people by what happened in the Lok Sabha and what have we done to correct it in the Delhi Assembly election. We would be very happy, but they don't say anything about it. They maintain a majestic silence.
Right. One quick question before we wind up the interview that regarding the appointment of the new CEC. Now, since the next hearing is on 19th, you still would say that there is no guarantee the government might still go ahead with the appointment of the new CEC, or would that veiled threat by the court, where they said that if something happens in the interregnum, then serious consequences might follow. So, would you think that that line can deter the government from going ahead regarding the appointment of the new CEC?
A, I would say there is no guarantee at all.
Okay.
B, I would say I do not consider that sentence to be a veiled threat.
Okay.
That
Okay.
sentence is what the court has said. Whether it is a threat or it is a guideline or it is a suggestion, I don't know.
All right. Thank you so much, Professor Choker, for joining on the Federal.
The Federal and City Union Bank jointly present the Tanjavur Marathon 2025 on Sunday, February 23. This event is powered by Sri Kamachi Medical Center and Anandam Silks and organized by Tanjavur District Athletics Association.